My name is Christine Bremer Muggli. I was a presenter today at the State Bar Institute on litigation, and our topic today was on discovery, and in particular I spoke about discovery abuse. The scope of Wisconsin's civil procedural discovery rules is really meant to have wide open discovery and disclosure by all parties, so that there isn't any longer trial by ambush, that all the parties have good, full information before they try a case. And that's really what the rules are all about. And so what we found recently in the last few years is this problem with really obstreperous conduct in the course of deposition. And so what we wanted to do today to give a back-to-basics prospect to people so that they would understand what we were talking about was to say, look, this is what you can do when you get faced with a situation in discovery when the opponent is preventing your witness from giving an answer or preventing his own witness from giving an answer. So we wanted to give the tools to young and older lawyers as to know what exactly to do when you're faced with that situation. One of the things that generally happens is that you get angry, so that if a question is asked and you know it's a good question and the lawyer on the other side simply refuses to allow his witness to answer, your tendency as a litigator and as an advocate is to get a bit angry and to start fighting about it. And that's exactly the wrong thing to do. You know, what you really need to do is know the rules, because the answer to all of these problems is found in the rules. So you have to keep a clear head. If your question can be corrected because there is a problem with it, you ask, what is wrong with my question, so you can correct it right away on the record. If you realize it isn't a question about it isn't a problem with your question, but really a problem with the lawyer not wanting his client or his witness to say something, then you go to the rules. And the rules will tell you that that is not proper. And you can do a number of things. You want to warn the lawyer what the rule is, remind him that the client has an obligation to answer. If that doesn't happen, then you want to tell the lawyer that you're going to stop the deposition and contact the court and ask the court to rule immediately on the problem at hand. Unfortunately, when you're a young lawyer, your first tendency is to fight it out, and you make a lot of mistakes and you say a lot of things on the record that doesn't do much except enrich the court reporter. And what you really want to do is take the time, read the rules, talk to other lawyers with more experience, and plan. You really need to know whom your opponent is. And if your opponent is known to be a Rambo type litigator, you have to be prepared for that and be ready to fight it out when you get there by knowing the rules and keeping a clear head. And sometimes one of the best ways to fight a Rambo litigator is to simply bite the bullet and put the deposition on videotape, because the best way to fight a Rambo litigator is to expose him for what he really is, or she.